Hello, everyone, and thank you for joining us for today's webinar about the Title V program and the Law Center's newest report, Public Property, Public Need, Using Vacant Federal Property to End Homelessness. Next slide, please. Today's presenters include myself. My name is Tristia Bauman. I'm a senior attorney at the National Law Center on Homelessness and Poverty. Also joining us is Juanita Perry, who is the Title V lead at the U.S. Department of Housing and Urban Development. Bruce Rosenblum, who is a Law Center board member as well as a managing director at the Carlisle Group, and Paul Varnado, who is an associate with Morrison and Forster. Next slide, please. And with that, I will turn it over to Janelle for some initial housekeeping matters.
Hi, everyone. Thanks for joining us. This is Janelle Fernandez at the National Law Center on Homelessness and Poverty. I just wanted to go over some really quick webinar housekeeping items with you. You are encouraged to submit questions to us during the webinar. We'll try to address questions when we reach the end. You can submit your questions using the text and comments panel on your toolbar on the right-hand side of your screen. You can also use the raised hand button if you have additional questions for us, or you can just type them into the question panel there. I do want to note that today's webinar is being recorded, and we will post this online. You'll get an email later this week with a link to that posted webinar video, the slides, and a link to the report that we'll be talking about today. We will ask a couple of survey questions at the end of this webinar just to gauge how good of a job that we did today. And with that, I will turn it back over to Tristia. Thanks.
Thank you, Janelle. As you have joined us today, I'm sure that some of you have some knowledge about the Title V program, but I think it would be useful to begin this webinar with the basic question, what is Title V? What are we referring to? Specifically, we're referring to Title V of the McKinney-Vento Homeless Assistance Act, which is an important federal law that covers a number of different subject areas, including within Title V, access to unneeded federal properties to be made available to homeless service providers for homeless use. What Title V of the McKinney-Vento Homeless Assistance Act does is provide a right of first refusal to unneeded federal properties. What does that mean? Well, the federal government is the largest holder of real property in the United States, and often it will find that it no longer has an ongoing federal interest in retaining the property that it owns. Before the federal government may sell or otherwise convey properties that are suitable for homeless use, and you'll hear from Juanita Perry at HUD about what goes into a suitability determination, the federal government must first offer the property to homeless service providers who may be able to turn that unused federal property into useful homeless housing or services programming. This is a fantastic program, not only because it allows homeless service providers to gain access to millions of dollars of unneeded federal assets, which can be, of course, a boon to homeless service providers and a boon to taxpayers who no longer would be required to pay for ongoing maintenance or utility services to properties that the federal government no longer needs. But best of all, title or lease of those properties upon a successful application is made to applicants for free. Next slide, please. So it may sound too good to be true, and the program has been in existence for nearly 30 years. And some of you may be wondering, does it actually work? Is it possible that we can gain access to unneeded federal properties for free? And the answer is yes. The program does operate that way, and it has a long history of success. To date, over 500 properties have been transferred or including 900 acres of land in 30 states and the District of Columbia. And that's over the lifetime of the program. Each year, over 2 million homeless and formerly homeless people are served in programs that are operating in former federal properties transferred to homeless service providers pursuant to Title V. Now, those are impressive numbers. But even that very impressive record is only a fraction of the Title V program's potential. This program remains a largely untapped resource because every year there are thousands of properties that are screened through the Title V program, and many of them are made available for application by eligible homeless service providers. And so part of what our interest is in issuing this latest toolkit is not only to apprise people about recent changes to the federal law governing Title V, which I'll discuss in a second, but also to conduct some much needed outreach and awareness building about the existence of this program and the way that it can help local governments and nonprofit organizations better serve the homeless populations in their communities. I referred to recent changes to the law, and you may hear more about this later on in the presentation, but just kind of a quick update. In late 2016, after the Law Center worked with a bipartisan coalition of lawmakers in Congress, the FAST Act, or the Federal Assets Sale and Transfer Act of 2016, was signed into law. And what that law does, in addition to creating a new disposal process for all federal properties, it provided some changes, important and improving changes to the Title V program that governs disposal of properties that are made available for homeless services and housing. Some of the changes under the new FAST Act to Title V include the clarification that properties made available under Title V can be used for permanent housing. Now, beginning sometime in the 90s, HHS did start to approve applications for permanent supportive housing. I will skip much of a description of what that is because I assume that a lot of the folks on this webinar are familiar with permanent supportive housing, but that is the type of housing intervention whereby someone who is homeless is provided with housing and then offered supporting services like, for example, mental health treatment services, substance abuse services, case management, or any other services needed to help maintain that person's housing stability. And while that's important, obviously there's a smaller number of groups that can provide permanent supportive housing than can provide permanent housing. We know that we are in the midst of an affordable housing crisis in this country, so the change under the FAST Act to allow permanent housing even without supportive services as an eligible use for properties conveyed under Title V is a huge change that we're hoping will place many more properties into the hands of local governments and nonprofit affordable housing developers, for example, to provide housing to homeless people who need it. Another important change that the FAST Act created was a streamlining of the Title V application process, and we'll talk about that later on in the webinar, but some of the timelines that you may have been familiar with have changed, so please do pay attention to that because the timelines are critical for submitting a successful application. And finally, I'll mention that a very important change, and this is something that, again, we will discuss in more detail detail later in the webinar, but applicants who are successful in applying for properties may choose to receive the property either by deed or lease at the applicant's discretion. And as we'll discuss later, that can be very helpful to avoiding the type of not in my backyard opposition that sometimes is imposed by either local governments or local communities when a federal property is going to be conveyed for homeless assistance in that community. Next slide, please. So now that we have an improved and very successful but largely untapped program, let's talk about how to take advantage of it. One consideration that, of course, is very important is to know what kinds of properties are available. Well, the variation is vast. There are a number of different types of properties that are owned by the federal government. Vacant land, for example. Sometimes that can be just acres of unimproved land. Sometimes it's land that has been used for a particular purpose. Like, for example, right now, there is a parking lot in downtown San Francisco that is no longer needed by the federal government that the city of San Francisco is pursuing under the Title V program. There are also warehouses. They can be very large or small warehouses. There was a medium-sized warehouse that was recently successfully applied for by the District of Columbia in downtown in the urban area of DC, and a number of warehouses have been transferred over time. Very large warehouses, for example, have been used in California to serve as food bank warehouses. Smaller warehouses have been converted to provide housing and other services. There also have been a number of office buildings that are made available and will be made available in the future, and that have been conveyed either to be remodeled for a particular programmatic purpose or that have served as office space for homeless service providers so that they may expand their programming. So what are some factors to consider when a particular property becomes available? One factor is whether or not the property is being offered for on-site versus off-site use. What that means is when a property is available for on-site use, the successful applicant would be able to gain access to the building and the land upon which the building sits and be able to use it for their proposed programming on site. Properties that are made available for off-site use are ones where the improvements to the properties, meaning the buildings that sit on top of the land, are available to be moved or used, but at another location because the land is not available. Typically, what we see is that properties that are made available for off-site use are ones that are located on military properties where there is an ongoing federal need for the land, but not a need for the improvements on the land. But what most applicants will find is that on-site properties are the ones that will be most useful because it does not require you to have an alternative location for the property or to pay expenses for moving a building from one location to another. Other factors to consider, of course, is the condition of the property. Sometimes properties are conveyed through the Title V program because they are dilapidated. Now, if they are so dilapidated, they may not be deemed suitable for homeless use. But there may need to be, for example, lead remediation, mold remediation. There may be asbestos remediation that is required. So you would want to consider the costs of remodel, but also rehabilitation to ensure that the property itself is safe for the type of program use that you are proposing. While title and or lease of the property is made to successful applicants at no cost, applicants do bear the cost of remodeling the property so that it can fit their program use and rehabilitating the property. Also, you want to consider whether there's any environmental remediation that needs to occur. For example, sometimes a field that has been used perhaps as for industrial use or has been a dumping ground may be available through Title V, but there's some environmental remediation that would need to occur before it could be adequately used for homeless housing and services. There are federal laws that bind the federal government outside of the Title V program regarding the state at which the property must be kept. But if there's environmental remediation that needs to be done in order for your proposed programming to begin operating, that also is something to consider and to ensure that you have funding for, and the time to do within the time constraints set forth under the Title V program that we'll talk about in a little bit. One of the best ways to see a property up close, or perhaps the only way to see a property up close, unless you're already familiar with it, is to arrange a site visit. It is best to attempt to arrange a site visit as early as possible. You are under no obligation at any time once you submit an expression of interest or an application to either follow through on that application at your discretion as an applicant. You can always decide not to pursue a property, so there's very little downside to taking the step to inspect the property through a site visit, and that's something that can be arranged with the landholding agency. Next slide, please. So once a property is available and you're interested, who may apply for that property? Well, there is a broad range of eligible applicants. It includes 501c3 nonprofit organizations as well as local governments. And that's both, well, it's all three: cities, counties, and state governments with agencies that provide eligible homeless services. Also, what is permitted are what are called joint applications. If there is a very large property, for example, and one nonprofit and or one local government agency cannot make full use of the property, rather than propose use for only a portion of the property, which may be denied, it would be advisable to submit a joint application whereby portions of the property are used by various groups that are eligible applicants for under Title V to provide eligible services under Title V, so that the property may be fully utilized, but you would not need to have only one use, provided that all of the uses are eligible under the Title V program. It is important that applicants demonstrate in their applications that they have the expertise, and while it's not a requirement that they have experience providing the specific programming that they're proposing, it does significantly strengthen an application if, in addition to having expertise on staff, the applicant could demonstrate that they have experience providing the particular programming that they're proposing within the Title V property if successfully conveyed. Next slide, please. So what does that mean? How can properties be used? Well, historically, we have seen uses run the gamut, and there is a really not much of a definition at all in the federal law or in the statute or the regulations about what constitutes an eligible use. Title V properties have been used for a wide range of things. It's important, of course, that the primary recipients of the programming be homeless people, but homeless services and housing can take a number of forms. Title V properties have been used for and may be used for emergency shelter, permanent housing with or without supportive services, job training. For example, the picture that you see here is of a program called Growing Home, which is located in Illinois. It's an organic farm where formerly homeless people are taught how to do organic farming. They then sell the vegetables to local restaurants and have a roadside stand that helps produce some income to sustain that job training facility. There are food banks, case management services, health services, administrative offices that serve populations from domestic violence survivors to veterans, to families, to people with diagnosed and living with AIDS, and any number of other types of services that are eligible under Title V that currently exist. If you are interested in seeing how Title V properties have been used, I would encourage you to take a look at the Law Center's last report on the Title V program entitled "This Land is Your Land," and that provides an overview of several properties and programs that are operating now to give you some sense of the diversity and also inspire some ideas about potential uses. And I will provide the information on how you can access that report at the end of this webinar. Next slide, please. So that is a general overview of the Title V program. I'm now going to turn it over to Juanita Perry, who is the Title V lead at the Department of Housing and Urban Development, which is the agency responsible for Title V screening and oversight as it relates to properties. Juanita, please take it away.
Thank you. Hi, my name is Juanita Perry. I am the Title V lead in the Office of Special Needs Assistance Programs within HUD. I will be going over the history of Title V as well as provide an overview of the Title V process as it relates to HUD. So Title V of the McKinney-Vento Homeless Assistance Act requires HUD to do three primary things. First is to canvass federal agencies of property that is unutilized, underutilized, access, and surplus, and to submit that property information using what we call a Title V checklist. We make the suitability determination based off of that property information that's on the Title V checklist to determine whether the properties are suitable to assist persons experiencing homelessness. And then we post the suitability determination on the HUD Exchange. It should be noted that HUD is now posting the suitability determinations on the HUD Exchange, but with the enactment of the FAST Act, which I will discuss a little bit later on about the other changes that came about with the enactment of this act, that we no longer have to post the suitability determinations in a weekly Federal Register. In the summer of 2011, HUD, GSA, and HHS filed an order to vacate the 1993 court order. This order actually governs the Title V process, and it actually, with this order, our statute and our regulations mirror what's in the order. On March 21st, 2013, the court denied the order to vacate and expanded the role of HUD by ordering HUD and GSA to develop a plan for additional and improved training programs for landholding agencies. In November 2013, HUD, in partnership with GSA and HHS, developed a Title V training webinar to discuss the role of each agency. And this training is, this webinar is actually located on our website, which is HUD Exchange. HUD has since presented in other trainings to further educate the public and our stakeholders on the Title V process. Now I'm going to discuss the enactment of the FAST Act of 2016. I've already mentioned how it changed the online postings. Before the enactment of the FAST Act, we were required to post our suitability determinations in a weekly Federal Register, which was very, it wasn't really user-friendly to the public and our stakeholders. So now we're allowed to post the suitability determinations on our website, which we call the HUD Exchange. Second, it streamlines it cuts the holding period for suitable and available properties from 60 days to 30 days. So now homeless service providers that are interested in a property that is listed as suitable and available in our suitability determination listings have 30 days from the date that that property is posted on the HUD Exchange to contact the Department of Health and Human Services, which is the federal entity that's responsible for the conveyance portion of Title V. And lastly, it allows HUD to not repost previously reported unsuitable properties with no changes. In the past, we had to republish everything under a particular federal landholding agency's inventory. So it may include properties that were unsuitable, but there was no changes. But with the enactment of the FAST Act, if the unsuitable property has no changes, then the landholding agency, then we are not required to repost the property unless the landholding agency submits the property information back to HUD because there's been some improvements to the property, for example. In an effort to better educate our stakeholders and the public, we actually redesigned our Title V webpage on the HUD Exchange, and I'm going to attempt to access that right now, so I can walk through what we actually have on our webpage. So first, we have like the home page. It just gives you very general information about the Title V process. What is the Title V process? Snaps and Title V and overview. And here is where we have our webinar that we did in partnership with GSA and HHS back in 2013. This webinar, like I said, it's an overview of the process, and it also goes into more depth about how each agency plays a role in the Title V process. And on the right-hand side of the screen, under resources, you see several links to other subpages of the Title V process. So the Title V process will actually go into the responsibilities of each agency, HUD, HHS, and GSA. So their requirements when it comes to implementing and administering the Title V process for their agency. As well as a diagram that I'm actually going to go through a little later in my presentation that kind of walks you through HUD's role and responsibilities as it relates to the Title V process. Under suitability listings, this is where we house the suitability determination listings. We also have previous Federal Register notices that we published starting March 10th, 2017. That's when we stopped posting in the Federal Register and started to just post our suitability determination listings directly on the HUD Exchange. And every Friday, we post a new suitability determination listing. One thing I forgot to add about the suitability listing, under where it says for more information and terms to know, visit the Understanding Suitability listing. This is just terms to know, to understand what we mean by certain terms in the listing, or just understanding what a suitability determination is, or what we mean by suitable, unavailable, suitable, available. And breaking down, we have a HUD property number that we assign to each property that HUD reviews for suitability. So just breaking down the information, breaking down the number so you can understand what the number means. I should note that we are actually, we're updating a lot of the information on our Title V webpage right now because of the enactment of the FAST Act. So a lot of information has changed, especially when it comes to, we have Title V FAQs, those are being updated. And we also have information about the appeals process. If you see a property that we determined to be unsuitable, there's a 20-day holding period for all unsuitable properties to give homeless service providers the opportunity to contact HUD to submit an appeals request. So this gives you the information and different ways that you can actually submit the appeals request to HUD for review. And then we wanted this webpage to be a place where our stakeholders can understand how the Title V process integrates with the other homeless assistance programs, such as the Continuum of Care program and the Emergency Shelter Grants program. So we have a brief blurb about that, as well as our partner organizations, GSA, HHS, ICH, and the Law Center. So we have links for each of those agencies you can click on and find out more information about the Title V program. Before I log off of our Title V webpage, I want to make note that under the suitability listing, we're actually in the process of developing a mapping tool that will list and show all suitable and available properties that can be used to assist persons experiencing homelessness. The tool will be an actual map. It has flags under each state that you can click on and gain more detail about the property. That will include, but not limited to, the property's name, the location, the condition of the property, the square footage, and if applicable, there will be a Google image there as well. If it is one of our federal agencies, military agencies, there may or may not be an image. But we're really excited about this tool, and the tool is forthcoming. We're still kind of testing the tool and tweaking it some. But if you are interested in being notified as to when the tool will be accessible, you can send an email to the Title V inbox. That's title, TITLE, the number 5, at HUD.gov. And an email will be sent out to notify you when the tool is ready, as well as you can contact the Law Center as well, because we will be in partnership with them to make sure that their contacts will know when we will launch the tool. Now I'm going to go over the process when it relates to HUD's role. So as I mentioned, HUD sends out, we canvass landholder agencies quarterly. We send out a letter requesting information about property that has been deemed underutilized, excess, and surplus. And we send out these canvassing letters by January 1st, April 1st, July 1st, and October 1st. Landholder agencies then have 25 days to respond back to HUD's letter. There are many agencies that opt to send property information on the Title V checklist in the interim of being of HUD's quarterly canvassings, like GSA, Interior, Energy, Agriculture, just to name a few. So once HUD receives the Title V checklists that are submitted from the agency, we have 30 days upon receiving the checklist to make our suitability determination. In the law, we actually have a little bit longer to publish the suitability determination. However, in practice, for many years, we have reviewed and published the suitability determination within that 30-day time frame. So if a property is deemed suitable and available to assist the homeless, this means that it did not meet any unsuitable criteria that's in our regulations, and we have the regulation citation up on the flow chart. There's a 30-day holding period from the date that is posted on the HUD exchange to allow homeless service providers the opportunity to contact HHS of their intent of a property that's listed as suitable and available. If there's a property listed in the suitability determination listing as unsuitable, there's a 20-day holding period to allow homeless service providers the opportunity to contact HUD and to submit an appeals request with supporting documentation of their request. So that's just an overview of the history of the Title V program and HUD's role in the Title V program, and just some upcoming things to look out for when it relates to the mapping tool. And I encourage you to go to the HUD Exchange and explore the different pages when it comes to Title V. And HUD will be sending out a listserv as well when we have made those updates to the language to reflect the FAST Act. So I'm going to turn it back over to Tristia to go over the application process.
Thank you very much, Juanita. We're really excited about the changes to how eligible applicants can search for properties. They're, as you heard, they're now available on the HUD Exchange website. There's no longer any need to go to the Federal Register. You can see pictures and get more information about the properties. Now I'd like to turn to what in many ways is the role that the Department of Health and Human Services plays in the Title V program, and that is in the application process. So once you have visited the HUD Exchange website, you've used their great new mapping tool and identified a property that you're interested in applying for, a question will arise. How do you go about applying for property? Well, the first step is to submit what is called an expression of interest. As Juanita said, properties that are advertised as suitable and available through the Title V program are held for a period of 30 days. Meaning that they cannot be conveyed for any other purpose, and within that 30-day period, it is necessary for any interested applicants to submit a brief expression of interest, which is a letter or an email to HHS, the Department of Health and Human Services, that identifies, excuse me, identifies the specific property. There will be a property number associated with the property. You'll also want to include, of course, any other identifying information like an address, for example. Briefly describe the proposed use. That really can be just a couple of sentences about what type of program you'd be interested in using the property for, and organizational information. That would, of course, include the name of your organization and also a description of whether you're a local government or a 501c3 nonprofit organization that is eligible to hold title to real property. The letter is very simple, and there's a template that the federal government has provided at the website that is listed on this slide. These slides will be available on our website, so if you can't hurriedly jot it down now, don't worry, you will be able to find it both on our website in this slide deck. Also, you can find in our report that we're releasing today, Public Property, Public Need, in one of the appendices, helpful links where you can also find this model form. Once a group has submitted an an expression of interest for a property, then you will receive from HHS an application. Now, one of the things that has changed under the FAST Act is the application process. Previously, under the former law, there would be a 90-day period within which to submit all application information to HHS. Under the FAST Act in 2016, that process has now changed, and it's been bifurcated into a two-part application process. First, an initial application is submitted, and there is a 75-day period within which to complete an initial application. After that, HHS has a short period of time to make a determination as to whether that initial application is approvable. If they determine that it is approved, then you receive a conditional approval and 45 additional days to complete a final application. At that point, once all information has been submitted, HHS will make a final determination about the application. Next slide, please. What goes into an initial application that applicants have 75 days to complete? Well, there is a lot of information. I'm going to go over a couple of the key pieces of information that applications require, but there are a couple of pointers that I would offer to listeners on this webinar right now. One, the timelines are tight and they are strict, whereby you may be able to receive an extension, usually of a period of 30 days when HHS grants that. There is no guarantee that you will receive additional time within which to complete your application. So sometimes it can behoove you to wait until the latter part of the 30-day period to express interest, to give you some time to begin gathering the information you know you will have to gather, and to work very quickly within the 75-day period to provide the information that HHS needs to make a determination on your initial application. I think it makes a lot of sense for anyone who thinks that they might be interested in submitting an application for federal surplus property to become familiar in advance with what an application requires. You can, again, look at the link that will be available later on in this webinar, and that is in the appendix of our public property, public need report to become familiar with the application so that you can have some sense of the type of information that you'll be gathering. Some of what you'll be required to produce is one, a description of the applicant organization, and we talked about that a little bit within the context of expression of interest. Are you a local government or nonprofit? What agency, if you're a local government, would be providing the services? If you're a nonprofit, are you eligible to hold title to real property? Are you tax exempt? And information of that nature, so that HHS can see not only that you're an eligible applicant, but also that you would be a good recipient for this unneeded federal asset. You also want to provide a description of the property, and this is a much more robust description than is required for the expression of interest. It's not just something that allows for an identification of which property you're talking about, but you also want to describe any proposed modifications that would need to be made in order to operate the programming that you wish to operate. Any easements that apply to the property, that includes both above ground and underground easements. What utility services are required in order to conduct the type of programming that you're proposing. Any zoning or code requirements that may be applicable, and things of that nature. Next slide, please. What else goes into an initial application? Well, one of the most important things that you should be describing, and in fact, this ranks highest among HHS's considerations of whether or not your application is sufficient, is a description of the proposed programming. What that description should include is not just the type of proposed programming, but also the scope of the proposed programming and size, like the number of people to be served in the property, documentation demonstrating need for the proposed services, and of course a description of modifications and the time needed to become operational in that programming. And I'll just pause really quickly to say that the pictures that you've seen, both the last picture, the picture on the last slide, and this picture here, are of properties that are currently available for application via Title V, and these were retrieved from the GSA website. And there's a link to that later on, but this gives you a sense of the diversity of the type of property that's available through the Title V program. You also want to provide environmental information. This is a large section of the application. In fact, previously there was a 10-page environmental questionnaire that was included within the application, and there's really very little reason to think that that aspect of the application will change much even under the amendments to the program pursuant to the FAST Act. So the type of environmental information that you would need to provide include, of course, information about the state of the property, which would be conveyed as is to applicants, but also information about the environmental impact of any proposed programming that you wish to operate. Finally, zoning and local use restrictions. I just want to make a point here about zoning and local use restrictions. One of the things that we have historically seen with respect to the Title V program is sometimes an applicant can be successful in applying for a property and receive approval from the federal government, but face opposition from the local government. And oftentimes that opposition comes in the form of zoning restrictions that will not permit, for example, the type of residential programming that is being proposed in an area that is zoned for industrial use. That's just an example of something that we have seen before. So one change that I mentioned earlier under the FAST Act to the Title V program is that now applicants who are successful can choose whether or not they want the property to be conveyed to them by deed or by lease. One of the things that is an advantage to receiving a property by lease is that when a property is leased from the federal government and the federal government retains ownership of the property, the local government does not have jurisdiction to require compliance with local zoning laws. The federal property is exempt essentially from the local zoning restrictions on how the property is used. So that can be an advantage to receiving a property by lease. However, of course, there are advantages to receiving a property by deed, and the public property public need toolkit does describe some of the relative advantages of receiving property either by deed or lease, but I wanted to mention that here in the discussion of zoning and local use restrictions. Next slide, please. Once an initial application has successfully been submitted within that 75-day period and or within the period agreed to by HHS, if you are in need of an extension and are able to secure an extension from HHS, and it's always better to seek that sooner rather than later so that you have a good sense of what your strict timeline is for turning in a complete application, you will have your application reviewed. And I'm noticing the time, so I'm going to go quickly through what we what by statute is the order of priority, but services offered, I'm sorry, by regulation, services offered, extent and range of the services, the need for the program. You want to demonstrate that the type of programming offered is one that is in fact needed in the community, that the property will be fully utilized, that the implementation time restrictions will be met or requirement will be met. That's 12 months for properties that do not need extensive rehabilitation, remodeling, or environmental remediation. There is a maximum period of 36 months within which to become operational. If you think that you may not be able to become operational within that time period, there are some things that are contemplated within the Title V law, but really, when you can propose programming that can become operational within that time period to avoid triggering a reverter clause. Also, experience of the applicant in providing the type of services that are being proposed, which would include demonstrating that you've had success in operating similar programs. And some of that can be demonstrated through getting recommendations from various levels of government authorities or peer organizations. Next slide, please. After an initial application is submitted, then HHS does review, and they have 10 days to make a determination on the initial application. If they find that information submitted to it is incomplete, HHS may request more information or clarification of some of the information provided to it, and then you'll be given an additional timeline for providing that information. If the application is approved, then applicants have 45 days more to submit a final application. Next slide, please. What goes into the final application? Well, under the new process, what needs to be described in the final application is the financing plan. Specifically in the law, what is required is a reasonable plan to finance the proposed programming. What should go into your financial plan are a discussion of operating costs, costs of rehabilitating, remodeling, or and maintaining the property over time, a description of the sources of funding, and these should be described in detail. While it's not necessary for applicants to have funding available on hand at the time that they submit the application, those funding sources should not be speculative. They should be reasonably likely to be available to the applicant within the time frame necessary for becoming operational. That's that 12 to 36 month period that we talked about. The more guaranteed the financing, the likelier it is that HHS will find that your application is approvable. So it is very important that you have a budget and sources of funding largely lined up in order to receive an approval of the application. HHS then has 15 days to make a final determination on the application. Next slide, please. There are a number of ways to gather the required information. Because of the short amount of time we have left, obviously the landholding agency, sometimes that's GSA, sometimes it's another agency, will have a lot of the information that is listed here, site visits as we've talked about, and then also you want to contact HHS or any of the other federal agencies necessary as soon as possible, as early as possible in the process, as well as any other government that may have knowledge about how the property has been used, so that you can answer questions about it. And the toolkit provides more information about how to gather the information you'll need to complete a successful application. Next slide, please. And hopefully after all of this, you'll receive a letter saying, congratulations, your application has been approved. So what happens after a final application is approved? Well, at that point, the property is transferred, and there's no set timeline in the law, but it's supposed to occur promptly. There is, as we discussed, no charge for title or lease, so that you will receive deed or lease at your discretion without being charged for that. The holding period is 30 years. And the reason why that holding period is relevant is that the property must be used for the approved purpose for a 30-year period unless there is an agreement made with the federal government to change the way that the property is used. How can the federal government know that the property is being used the way that it is supposed to? Well, there are annual reports that every applicant must submit. Every successful applicant and now transferee must submit to HHS about the type and number of people served and other information showing compliance with the proposed program. If a transferee ceases to use the property in the way that it is supposed to under the transfer agreement, or if it attempts to sell the property, then something called a reverter clause is triggered, and the property can revert to federal ownership. Next slide, please. There are some helpful websites. I'm going to move quickly past that because that information, as I said, is going to be available on our website in this slide deck. You can also get it in our report, which is available for download from our website now. There are several tips for a successful application that you can learn from the report, and also please take a look at some of these listed, some of the more important ones listed on the slide. But I do want to get quickly to our technical assistance. So at this time, I will introduce some of the members of what we're calling our Title V Technical Assistance Team. The Law Center will provide technical assistance, and we've enlisted the support of pro bono partners and others to assist us in providing technical assistance to interested applicants to help improve the chances you'll be able to successfully apply for Title V properties. And with that, I will turn it over to Bruce Rosenblum, the Managing Director of the Carlisle Group and Law Center board member.
Well, I'll be very brief given the time, but as you've heard, the Law Center staff can assist in many of the details of putting together a successful application, and we have great pro bono resources at some of the best law firms in the country who have also volunteered to provide assistance. I've offered as a Law Center board member and someone who has been working on the investment side for the last 17 years to assist as appropriate and assemble others to assist to the extent there are non-legal areas of the application, such as putting together a financing plan and budget, possibly dealing with real estate development issues, where some of these additional resources could be helpful. So that's really just a general statement of availability, and the details will depend on need going forward.
Thank you very much, Bruce. Also, I will turn it over to Paul Varnado, an associate with Morrison & Forster, who is also providing technical assistance support.
Thanks, Tristia. So I'm an attorney here at Morrison & Forster in their Washington, D.C. office, and the Law Center's primarily engaged our help as outside legal counsel to monitor government compliance with Title V. So that's both with the letter of the law and the spirit of the federal court orders, kind of that are aimed to get better, meaningful compliance with the program out of the federal agencies. So as part of that, what we want to do is hear from you all as you're navigating the process and running into problems or issues. Some examples are when there are very complicated interplay between state and federal laws involving environmental remediation. Many of the sites, as Tristia mentioned, require quite a lot of cleanup before they're habitable. And we're happy to help groups think about and talk through those issues. Also, we do quite a bit of legal research for the Law Center on administrative law. In other words, what the Administrative Procedures Act requires of the various agencies and how it requires them to implement Title V. So going forward, for one, am very optimistic that the new reforms will meaningfully improve the program, but we want to hear from individual applicants and work with you as you're navigating the process to make sure the agencies are complying as best they can and make sure we can help you successfully obtain a property.
Thank you very much, Paul. Quickly, I'll mention that we will have support also from Ballard Spahr. The firm of Covington and Burling partnered very closely with the Law Center to achieve some of the positive changes to the law, to the Title V law under the FAST Act, and will continue to work with us on agency advocacy, which again, your stories and experiences can be helpful to informing. I encourage everyone to reach out to the Law Center, both so that you can gain access to our expertise, the expertise of our fantastic group of partners who are assisting with the technical assistance, and also potentially be connected with former applicants who can give you their experiences and lessons learned through the application process. Next slide, please. So we're nearly done. Thank you all for bearing with us a few minutes over here. This is my contact information. Please do feel free to email me or call me at 202-638-2535. I apologize for not listing the phone number here on the slide. Please do go to our website, www.nlchp.org, in order to download the public property, public need toolkit, which is formatted as a Q&A document that will be a useful resource for you as you look for and apply for Title V properties. And I will turn it over now just for some final housekeeping matters. If you just bear with us for one more moment to answer a couple questions about whether you found this information to be useful, we would very much appreciate it, as it helps inform us and make us better in the content that we provide to you. Thank you all very much for joining us. Janelle.
Thanks, Tristia. Hi again, everyone. This is Janelle Fernandez here at the Law Center. You should see on your screen right now a poll that we are asking you to just click right there in the screen and answer the poll for us. We would like to know if, as a result of this webinar, do you have a better understanding of the Title V process? Your options are yes, a lot, yes, a little, or no, not really. And I'll give folks just a few more seconds to answer. Again, you can just click right on the screen to respond to that poll. And this really helps us understand if the content that we're providing you is helpful, if the information that we're sharing is going to be put to good use. So looks like most folks have voted, so I will close this one out and I will share these results with you, which look great. 78% of you said yes, as a result of this, you have increased your knowledge a lot. 22% yes, a little. So that's fantastic. And we have just one more question before we move on to our Q&A. And so one more survey for you that will appear on your screen now, which is, are you going to use the information that you learned today going forward in your work or in your advocacy? And so your options are yes, no, or not applicable. So again, please just click right there in the screen to respond to that survey. And again, this really helps us understand if the information that we are presenting to you is going to be useful and helpful to the folks actually doing this work throughout the country. So I will give folks just a few more seconds to respond. Great. Okay, so I'll share the results with you. And this is great. 95% of you responded that yes, you will be able to use this information in your work or your advocacy going forward, which is really fantastic and great to hear. So I will hide this and we'll move on to Q&A. And before I pass it back to Tristia, I just want to answer our most frequently asked question, which is, will this information be made available to everyone? Can you get copies of the presentation and the slides? And the answer to all of that is yes. later this week. Everyone who attended or registered for this webinar will receive an email with links to the reports that we've been discussing so far, with links to the slides of this presentation, as well as to a video recording of this entire presentation. So keep an eye out for that email coming to you later this week. And with that, I will pass it back to Tristia for some additional questions.
Thank you very much, Janelle. I'm making note of the time, and we are 7 minutes over our scheduled time. And I really appreciate everyone who has stuck around. What I would suggest that we do, since there was a lot of information, I'm glad it was helpful, rather than keep people longer for a Q&A session, the Law Center will look at the questions that were submitted in writing, and where we can answer, we will answer specific questioners. Please do visit our website at www.nlchp.org. Take a look at our public property, public need toolkit, which was released today, hot off the presses. It's a short, very digestible document in frequently asked question format. Take a look at that and let us know if you have additional questions, and please do not hesitate to reach out to me with general questions about the program. And certainly, if you find that you are interested in pursuing a property, contact us early and often. We're here to help you. Thank you all very much for attending.